case, all we mean is that the defendant desired or knew that his or her act would result in an entry on that particular realty. Suppose, for example, that a friend of mine says that I can go and use his cabin in the mountains to go study for my final exams, and he gives me the key and he gives me directions. And I follow his directions and I drive to his mountain cabin. But by the time I get there, my friend has suddenly had a need for money and he sold the cabin to his neighbor for $10,000. Well, I don't know that. I don't have a car phone. So when I get to the cabin, I let myself in with a key. Did I desire to go into that cabin? Yes, I did. I had the intent to enter. Since the cabin now belongs to somebody who did not give me permission to enter, I have probably committed a trespass to land. If that bothers you, remember, I'm not going to go to jail for it. I'm only going to have to pay. Pay what? Pay for the damage I did? Trespass to land doesn't require any damage, as we'll see. The second element is entry on plaintiff's realty. What does entry mean? Well, the simplest kind of entry is going in or going on the realty. But actually, entry onto realty occurs when anything tangible makes contact with the realty. Tangible. There are a few courts that have allowed trespass to land actions in the case of entry by gases, by dust, even by radiation. But those jurisdictions are definitely in the minority. Right now, there is no entry unless something tangible touches the realty. What do we mean by the realty? Realty is land, anything permanently attached to the land, some of the airspace above the land, and how much air depends upon what state you're in, and some of the earth below the surface of the land. Again, how deep below the surface depends upon what state you're in. Remember, it isn't necessary that the defendant make physical contact with the land so long as the defendant causes that physical contact with the land. So you may read a case about a fella that was shooting ducks and he shot a bullet that passed over the plaintiff's land, through the air over the plaintiff's land. And the court said some of the air belongs to the land and therefore entering the air over the land was contact or entry on the realty. In that case, the defendant didn't go there himself. He shot a bullet that went there, and it didn't even touch the land. It went through the air above the land. But it was an entry onto the realty. Finally, the entry must be unauthorized, and that simply means that the person in possession of the realty did not give permission for the entry. Incidentally, sometimes remaining on the realty after permission has run out is regarded as an unauthorized entry. That's trespass to land. Remember, no damage is required in a trespass to land case. You may come across a case in which the court said, in every unauthorized entry onto land, there is damage, even if it is just the treading of a blade of grass. And I'm telling you now that even if no blade of grass is trod upon, damage is not required in a trespass to land case. The next two invasions of property rights are very closely related. In fact, in some ways, the difference between them is just a matter of degree. We're talking about trespass to chattel and conversion. You know, the common law of England began developing, and our common law comes originally from the common law of England. The common law of England began developing at a time when records weren't kept very well. Most people couldn't read anyway. Most courts weren't in touch with each other. Fax machines didn't work as well as they do now. Nobody was on the internet in those days. And so different courts in England developed different methods of dealing with the same problem. The problem was, what are we going to do if somebody intentionally messes around with my chattel? Chattel, by the way, is any property other than realty. What are we going to do if somebody messes around with my chattel? And the courts came up with two different ways of dealing with it. One of them was called trespass de bonus aspertatis. You don't really need to know that. Nowadays it's called trespass to chattel. And it was a tort action for damage that resulted from messing around with someone else's chattel. Other courts developed another approach which was called trover, and you don't really need to know that either. Nowadays it's called conversion. And it was based on a kind of contract theory. It went like this. That person messed around with my chattel. He took my chattel and made it his. So there's an implied promise that he would pay me for it. In other words, when he messed around with my chattel, he bought it, whether he wanted to or not. And that's the theory of conversion. Now, both of these torts involve the same essential elements. Intent, interference with plaintiff's chattel, and damage. Intent, interference with plaintiff's chattel, and damage. The real difference between them is the seriousness of the thing, because if I sue you for trespass to chattel and I win, you're going to have to pay the damages that I sustained as a result of whatever it was you did to my chattel. But if I sue you for conversion and I win, you're going to have to buy the chattel from me for whatever it was worth at the time you messed with it. Of course, I have the choice. I don't have to sue you for conversion if I don't want to. If I don't want you to buy the chattel, if I want to get it back, I have to sue you for trespass to chattel, because if I sue you for conversion and win and you pay the judgment, you become the owner of the chattel. That's why conversion is called a forced sale. A forced sale. And a forced sale is a very, very stringent remedy. And for that reason, the law of conversion usually requires a more serious interference than the law of trespass to chattel. But let's look at the essential elements. Both of them involve intent, and as we know, in a case of interference with property, intent just means a desire or knowledge that that particular thing would be affected by my conduct. So, for example, if I have a very unusual yellow and purple polka-dotted Edsel. I think it's the only one on earth. And I parked it in parking spot number 17 when I came in here today to talk to my class. While I was talking to my class, somebody stole that car. And later on, by pure coincidence, somebody else parked in spot number 17 who also happened to own a yellow and purple polka-dotted Edsel. When the class is over, I go outside, I see a yellow and purple polka-dotted Edsel in spot number 17. I'm absolutely sure it's my car. I got a right to do anything I want to the car, and so I go and paint flames on the car. Well, it wasn't my car. The car belonged to someone else. Since I desired to paint flames on that particular car, I have the intent necessary to be liable for either trespass to chattel or conversion. Because intent just means a desire or knowledge that that particular thing that I was looking at, that I was painting,